Reorganizing the farm business number 6.
One of the dramatic effects of forming a family farm corporation is the transformation of those individuals who were previously self-employed into employees. It may have been a partner in a partnership, or may have been sole proprietor in a sole proprietorship, but those individuals may very well become employees when the corporation is formed. And there are financial effects that flow from that transformation. There are legal changes, and there's some very important and practical psychological ones too, because no longer can the person say that is my tractor or that's my 160 acres, because the farmer in that case becomes the corporation, and the individual works for the farmer, works for the corporation as an employee. Certainly that is true if the corporation is carrying on the operation of the farm business, as opposed to, say, an owner of land that rents that land out to a tenant with the corporation owning the land. But apart from those psychological adjustments, there are certainly some important financial and legal ones, and let's take a quick look at some of those. One effect is more Social Security tax in nearly every instance upon the shift to employee status. As you'll note, a self-employed farmer pays more Social Security tax than would an employee. However, that isn't the end of the Social Security tax liability for an employee situation, because the employer also pays a like amount of Social Security tax equal to that of the employee. So together, those two amounts exceed the Social Security cost for the self-employed individual. There are some offsetting features. That is to say, no part of the self-employed person's Social Security tax is income tax deductible. However, the employer's portion of Social Security tax is income tax deductible, and that helps to offset a part of that extra Social Security tax cost. Another feature, if wages are paid to a child under age 21 who works for his or her parent, then Social Security tax is not due. But if that child under age 21 works for his or her parent's corporation, then Social Security tax would in fact be due. And so there's that added feature there. It is possible for employee status, however, to lead to possibly higher Social Security benefits in retirement. And that's because employee status with salary or salary plus bonus could lead to a more even income over time. A self-employed farmer's income will often fluctuate, up some years, down in others. But an employee's income will be more stable, and of course if a self-employed person's income drops, that may hurt the individual ultimately in terms of Social Security benefits in retirement. And if the income then goes up in a different year, that does not then that is not credited then to help the individual in terms of benefits if that amount goes above the current covered amount for Social Security. So to assure maximum benefits to which the person could perhaps be entitled would require at least the covered amount be received in income, and that can perhaps best be achieved through a relatively stable income in the form of salary or salary plus bonus. So there's that aspect as well. Moving on to some of the employee benefits that likewise can be associated with employee status. Might mention health and accident benefit plans. The corporation could take out health and accident insurance policies, pay the premiums, for example, to cover the employees. There's possibility for group term life insurance for the employees. This is about the only place where the premiums for life insurance are income tax deductible. They are here if it is a qualified group term plan. And most states require at least 10 employees, so on the surface of it, it would appear that many farm corporations might have difficulty qualifying. But there is what is known as the baby group plan, where a group of less than 10 can be combined with another group of less than 10 perhaps, so that a larger group can be put together for the writing of the policy. And we've now known, or we do now know, that the benefits, income tax deductibility, for example, of premiums, is assured for a baby group plan if certain requirements are met relative to discrimination, and so the plan does not benefit too much the highly paid individuals. Might mention also retirement plans for employees. Now, a self-employed farmer will be eligible for retirement plans also, the so-called KEO type, or HR10 as they're called, but the employee plans generally are a little bit more attractive, and employee status, therefore, would be needed to take advantage of such a plan as a corporation could set up. Perhaps a defined benefit plan, the old pension plan, or a defined contribution plan, the old profit-sharing plan, where contributions are based on profits of the firm. A relatively new retirement plan, the employee stock ownership plan, or as it's come to be known, the ESOP, where the plan is funded by securities of the employer corporation. Those are relatively recent in terms of use and are gaining a fair amount of attention. We might also mention, as we talk about employee status, that after incorporation, an employee may very well have some different kinds of income tax concerns because the individual may be using the corporate automobile, perhaps living in the corporation's house. Let's take the house question first. Before incorporation, a self-employed farmer may be able to deduct, or should be able to deduct, the property taxes on the residence, any interest associated with the residence on a mortgage, for example, but the other costs are not deductible, except as perhaps a business use is carried on in the residence. So if an office is maintained in the home regularly and on an exclusive basis, then a portion of the residence could be treated as a business asset. Otherwise, the other costs of the residence are not income tax deductible. But if that residence is transferred to the new corporation, then the corporation would normally treat it as a business asset with quite different treatment than of the costs involved, because it would be a business asset and would be treated accordingly in terms of deductibility of expense. But then the question comes up, the other side of that coin, what about the people who live in the corporation's house? Are they receiving a benefit? And more importantly, are they receiving a taxable benefit? And might very well be taxable. There are about 3 ways of handling that benefit that is received in living in the corporation's house. We raise this question, of course, if it is an owner who lives in the corporation's house. If it's an employee who's not an owner, a hired person on the farm, then we generally wouldn't be raising this question with the same urgency as we do when it's an owner who lives in the corporation's house. And there are about 3 ways of handling that benefit from a tax point of view. One would be for the individual living in the corporation's house to pay a reasonable rental to the corporation for the right to live there. The second possibility would be to report on the individual's income tax return the fair value of the benefit of living in the corporation's house. A third approach was based upon a part of the Internal Revenue Code that was enacted years ago to provide for the situation where an employee is required by the terms and conditions of employment to live on the premises, possibly eat meals on the premises. And it provides that if that's the case, the meals and the lodging are not taxable income. And those rules were designed to cover situations like a department store clerk supposed to eat lunch on the premises to be able to continue to service those who come in to buy items during the lunch hour, or for someone who's involved in security, night watchman, who is given a place to live so that it can be on the premises. But farmers have also made the argument, and it's been especially compelling in livestock operations, that they perhaps have to be on the premises as well. And in some cases they've been successful, in other cases they have not. This is a point that ought to be checked carefully with the tax advisor, with the attorney, to see if it appears that that section of the Internal Revenue Code would be helpful with respect to handling the expenses associated with living in the corporation's house. Another problem in this area, as we had noted a moment ago, is the matter of using the corporation's automobile. Now, before incorporation, the self-employed farmer will usually, on the income tax return, deduct a portion of the expense, that portion that would be associated with business use, and it's usually a percentage. After incorporation, if the automobile is transferred to the corporation, then the corporation might very well deduct the full amount of the automobile cost. Then any personal use of the corporate automobile would be a benefit to the user, and it's generally considered a tax benefit, and it may perhaps be approached on the ground of a fraction of the cost, again, only now we're reporting it as income on the tax return of the user, or perhaps by keeping track of actual mileage driven, and that percentage or that proportion of the total driving would be treated as personal as opposed to business expense. There are some other problems, though, associated with that automobile owned by the corporation. One is liability. If a corporation owns the automobiles that are used heavily for personal driving, then the corporate liability extends to all the driving involving that automobile. So if a 16-year-old son of a shareholder takes a car into town on Saturday night and wraps around a tree, that may expose the corporation to liability, and that may be more liability than some of the people in the corporation at least think would be appropriate. So that it's important to look at that aspect as well. But don't assume that just because you leave the automobiles out, you're avoiding that problem entirely. You may not be. In one case not too long ago, a department store manager was running a midsummer sale, ran out of one line of merchandise, called his colleague in the next town who ran a similar kind of department store to see if supplies were available there, and they were. So he hopped in his car, went to the next town, loaded up his vehicle. It was a hot, humid July day, and after he'd loaded up his automobile, he felt the need for a cool one, so he stopped at the local watering spot, and he had one cool one. A friend came by, had a second one, decided he better get back to work, so he went out, hopped in his vehicle, took off, had a terrible automobile accident. The injured party sued him, as well as his employer, and won because he was acting within the scope and course of his employment. So the employer does not avoid liability just because the automobile is not owned by the corporation. Keep that in mind as well. We might then try to conclude this segment, looking at employee status, by examining, going back to our chart again, what does employee status then mean for the corporation? And I would suggest that we're really talking about a situation in which employee status may bring pluses, it may bring minuses. The plus obviously means that employee status may give more tax benefits. There may be some psychological problems here of becoming an employee, and there may be some statuses like workers' compensation that may not be all that desirable, and so we would have to give employee status a plus and a minus both. Probably we would, on balance, tend to tilt a little bit more toward the plus side, although we think that there are enough minuses to certainly mention that as well. And so I think we can conclude here that employee status is often a mixed bag, and we will return for the final segment in this series. We're talking about the transfer of stock, the estate planning aspects, and dissolution. Because of concerns about large publicly held corporations engaged in farming and absentee ownership of farmland, a number of states have adopted limitations on the use of the corporation in farming. And the federal government likewise has imposed limitations with respect to some lending, or federally related lending agencies have limitations. For example, the Farmers Home Administration in loans to farm operations, subject to some limitations for loans to farm corporations. For Production Credit Association, Federal Land Bank loans, Those can be made to farm corporations if one of three tests is met. And those are generally met by most family farm operations. First, if more than 50% of the stock is owned by farmers, or if more than 50% of the assets are related to agricultural production, or if more than 50% of the income is from agricultural production. And so it's, generally speaking, not too difficult to meet any one of those three. In fact, most operations would meet all three, as a matter of fact. We might take a look then at the question of stock transfer. We have discussed the development of the stock structure. We've developed the possibility for use of debt capital as well as equity. We've talked about debentures, we've talked about bonds and notes as well as stock. One of the important uses of the corporation is to help the farm family solve their estate planning problems. And so let's consider some of the features of the corporation as it might be used in terms of helping the parents solve their estate planning problems and the transfer of stock. What is it about the corporation that may make the transfer of stock easier than would be the case for the transfer of 160 acres of land directly, or the transfer of 10 head of steers, or any other tangible asset? Well, one aspect is that for stock, you can transfer stock to the children, for example, without really losing control over the assets involved, without really losing control over that wealth, because it's possible to have restrictions on stock transfer, and as long as the parents retain control from a voting point of view, that is to say, in the typical case, as long as the parents retain at least 51% of the stock, they really control the decision-making process, because they can control decision-making at the shareholder level, and because of that, they then can control the election of members of the board of directors, who in turn control the officer selection and decision-making at that level. And so that certainly is an important aspect that may cause the parents or lead the parents to be more willing to make transfers. It is also possible with the corporation in an estate planning use, in transferring stock to children, for the parents to be able to plan for property transfer in the form of stock in a way to simplify their estate settlement. It is much easier to settle an estate if all that a person had at death was a block of stock, because it simply means that you have to value the stock, vote the stock at the annual meeting during the course of estate settlement, value it, pay the tax, and that may be about all that's involved. It's a lot easier than it is to settle an estate that involves a line of farm machinery, growing crop, perhaps some stored grain, great deal of livestock. That's a more complicated situation in terms of estate settlement. Also, if the farm family owns land in more than one state, it may be necessary, if the landowner, say the father, dies, to have a separate estate settlement proceeding in each of those states. This is called ancillary probate, or the settlement of the estate first in the estate where the person died a permanent resident, but then having a separate estate settlement proceeding in every state where land is owned. And that can become expensive, involve red tape, and so on in those various states. So as families begin to develop land ownership in other states, they sometimes use the corporation, because then at death, they own corporate stock. Corporate stock is personal property, and it can pass under the law of the state of permanent residence at death. So it may avoid the necessity for having estate settlement proceedings in other jurisdictions in other states. Thirdly, it may be possible in some instances to use a simplified estate settlement, because the ownership of land is not directly affected by death of an individual. The land, if it's held by the corporation, continues to be held by that owner, the corporation, and the death of the shareholder doesn't directly affect that. And land title is one of the more compelling reasons why we settle estates formally. I'd also mention that with stock, transfer of stock to children leads to less likelihood that the children, as minority owners of stock, might demand at some point, or their families, or their spouse, or their creditors might take steps to try to acquire the ownership of that asset later on. For example, if the parents give, say, 160 acres of land to the children, the children's creditors, or if there's a marriage dissolution, the spouse might end up with that property. With stock, A minority individual who's a minority shareholder does not have all the same rights to acquire an interest because there is no partition and sale. A minority shareholder cannot demand that their portion be set aside for them, simply not available to a minority shareholder like it would be to a minority holder of an interest in land, for example. So there's far less likelihood that a minority interest will be set aside to that minority owner. We'd also mention that it's easier to make transfers to minors. You can use the Uniform Gifts to Minors Act for transferring stock. You cannot use that for gifts of tangible assets like machinery and livestock and equipment, so it may be easier to move property into the hands of minors using a parent or another adult or a bank as the custodian to manage the stock until the child reaches the age for distribution. But also mention that it's easier to move a farmer through the retirement years with the combination of part-time salary, of dividends, interest on debt securities perhaps, can be used to move the farmer through the retirement years and receive Social Security benefits to which they are entitled by virtue of their earlier service. We might spend a few moments now on the matter of dissolution, because for the corporation this is probably one of the more substantial disadvantages. And for most corporations, if they are considering dissolution, they have essentially two major routes to go. One possibility for dissolution, and here we're talking about really the tax aspects of dissolution. We might add parenthetically that from a formality point of view, there are some things that need to be done, some documents filed with the Secretary of State, but the bigger concern has to do with the income tax treatment. And the usual dissolution involves payment of income tax on the gain measured by the difference between each shareholder's income tax basis for the stock and the value of the distribution to that shareholder, so that we might very well have a rather significant amount of capital gains tax to pay on dissolution. There is another method of dissolution, liquidation. This is called the special quickie 1-month liquidation. And with that one, if there is enough agreement of shareholders, then upon the liquidation of the corporation, there will be income tax paid on the accumulated earnings and profits. Those amounts will be reported as ordinary income, really reported pretty much as a dividend. Then the other assets that have increased in value, like land, could be removed from the corporation without paying tax on the gain. So one of the more important questions before liquidation is undertaken and the accompanying corporate dissolution is to check to see which of these two basic dissolution approaches would be preferred. Now, there's also a third possibility if it is contemplated that not only will the corporation be liquidated and dissolved, but there will be a sale of the assets. And there's a special provision that can be used to avoid a double tax. That is, a tax on sale of the assets followed by another tax on liquidation of the corporation. And so those who are contemplating that kind of a liquidation, that pattern, should keep that, of course, in mind. Well, with this discussion of the dissolution process and look at the transfer of stock, let's go back to our chart and let's see how the corporation scores on those points. We have just finished discussing the matter of ownership, transfer, and dissolution, so let's begin at that end and note that for the regulatory tax corporation, dissolution must rank as a negative. It's a clear minus because there will be some income tax liability, and it could, of course, be very substantial. Subchapter S corporation perhaps doesn't face quite that problem because in most Subchapter S corporations, there won't be very much in the way of accumulated earnings and profits, simply the way the earnings and profits are calculated. Therefore, that special quickie 1-month liquidation may look better, and there may be less gain on the liquidation of a Subchapter S corporation. Relative to ownership transfer, the flexibility of the corporation, for all the reasons we mentioned, probably for both a Subchapter S and a regular corporation, would mean that we would give pluses to those features. Looking at the finance side, there, I think, for both the Subchapter S and for the regular corporation, again, we're going to have to give it a plus in some respects, a minus in others, because, as we've noted, there are limitations, for example, on the borrowing from some governmental or governmentally related agencies. Yet there are some pluses as well, because with the opportunities that exist, the flexibility that exists to establish the debt security group as well as equity securities, that it may be possible to get some flexibility in the financing arrangement as well that cannot be obtained otherwise. Considering the matter of risks and liabilities, the corporation does have, both the regular corporation and Subchapter S, limited liability, meaning that the risks, the obligations of the corporation are borne by the corporate assets, and the shareholders then, as to their outside assets, as to their personally held assets, those not committed to the corporation, those assets are then protected from corporate obligations. So there's in effect an asbestos firewall around the corporation to protect those assets personally held from corporate obligations, except of course where the employee is also a shareholder and that employee is responsible for the act that leads to the obligation. And so in that case, we'd be dealing with a different situation, because there the personally held assets could be liable for corporate obligations. With respect to management and control, the corporation has a great deal of flexibility there, and this is true both for regular and for Subchapter S statuses, because with the corporation we have three decision-making levels. We have the shareholder level, where the basic fundamental decisions are made, the board of directors, where policy is decided, and then we have the officers, where they make the day-to-day decisions. And we might just review very briefly the control at those levels and the flexibility that comes from having those three levels, because the shareholders operate on the basis of 1 vote per share of voting stock, and a majority will normally govern. It's a rather harsh rule, the 51% rule, that may be a very important feature indeed for those minority shareholders who may fear that as a minority they may not have a great deal of participation in management and in decision making. There are some ways to modify, to pre-decide certain issues to protect the minority. At the board of director level, they operate on the basis of 1 vote per director. The majority vote will normally govern. At the officer level, they are executives. They're executing policy, and so we then have a 3-level breakdown in the decision-making process. Let's now turn, in our concluding moments, to a look at our total examination of the alternatives. Recall, we looked first at the sole proprietorship, then we shifted to the limited partnership, general partnership, and then the 2 varieties of corporations, and we examined them all from the standpoint of those same 8 characteristics. Now, you'll see from a review of all of those pluses, minuses, and zeros that it is not a clear-cut case in support of or in opposition to any one of the choices. And that's why we say there is no perfect form for organization of the farm business. It all depends upon the individual situation. And for some, a feature, for example, income tax treatment, may be a plus. For others, it may very well be a minus. And so we suggest that each individual consider carefully all of those characteristics and others that are relevant in the decision as to which method of organization will best serve the needs of the farm family. It's not an easy task. It's not an easy task indeed, but we suggest that a great deal of study should precede the actual decision as to which method to use.